There's also a question about how criminologists view crime, and their view of crime has changed over the years. So I've got this discussion here in three parts I'd like to show you as the evolution of different perspectives on crime. First, you've got the consensus view and the conflict view, and then we'll also talk about the interactionist view, sometimes also called the symbolic interactionist view on crime. Let's start up with consensus view. When you have a consensus, that means agreement, right? And so the idea here is that we basically agree that crime is unacceptable to all people. Crime is something that's abhorrent, and we don't want it, and we know what it is. This is rooted in a notion called social harm, okay? There are certain things that are obviously harmful to people, and that we ought to control those types of activities. So the notion is there are things that are harmful, we can agree on those, and that is what counts as crime. Okay? That's this consensus view. This view and these assumptions really dominated in the United States through up until, let's say, the 1950s. Okay? Then in the 1960s, we had a certain kind of event happen in the US. Can you think about what big social movement occurred in the 1960s in the US? Probably you're thinking about the civil rights movement, okay? This move toward equal rights for minority group members. So you had, for example, the Black Civil Rights Movement. Later, you had the feminist movement, women's movement. You had the American Indian movement. You eventually had the Stonewall riots and the development of the gay rights movement in the United States in the 70s. Okay, so what eventually started to be prominent is this conflict view that really increases in the 1960s with large-scale social upheaval, largely by minority group members who felt like they did not share the same rights as all citizens. So these theorists, these conflict theorists, believe that certain groups have more power, okay? That some groups get to define what counts as crime, and other groups are victimized by that arrangement. So this one really is a critique of the idea of who gets to decide what crime is, who gets to decide how laws are enforced, and that plays into what counts as crime. In other words, who is the criminal justice system protecting, right? That's a huge issue for conflict theorists. The final view of crime for different criminologists is interactionism, and this is actually something that I've been trained in, especially. So the focus is that it's fairly similar to the conflict view in that different people interpret the role of the criminal justice system and law very differently. But it also focuses on the process of what's called labeling. And we're going to look at labeling theory and approaches. And why is it that some types of things get labeled as crime or criminal and other things do not? How does that change over time? One of the more important theoretical contributions here is by a fellow named Howard Becker, who came up with this term I just underlined, moral entrepreneurs. And these are people or groups of people who take it upon themselves to change what counts as crime. A great example of this is MAD, the group you all know, I'm sure, Mothers Against Drunk Drivers. MAD basically came along, and the idea was that these mothers probably might have had children who were victimized by drunk drivers, maybe killed. So they argued for legislation to help criminalize drinking and driving. So these are moral entrepreneurs. They come along and they do innovative things to try to change what counts as crime, okay? So that means that in the past, maybe drinking and driving was not labeled criminal, but eventually has become labeled a crime. A criminology course also needs to consider where law comes from. And the origins of law are rooted in very early legal codes. And we've got some ideas here about two early codes that I'll go into briefly. The Code of Hammurabi goes back to 1750 BC or BCE, some people call it before Common Era. So we're talking roughly around 3,750 years ago, right? That's a long time. This was a code by a ruler, and Hammurabi promoted what's called lex talionis. It's a Latin term. And the term refers to punishment through some type of physical retaliation. Okay? So that's the definition of lex talionis. The most common application of lex talionis is an eye for an eye. So you see things like an eye for an eye, a tooth for a tooth, as a kind of a logic. And this was very common as a basis for law 3,750 years ago. We found these, and they were able to be translated, so we have this as a very early document about law. Mosaic Code relates, of course, to Moses. Moses was given the law from God on Mount Sinai, and this code goes back 3,200 odd years ago. And as I said a second ago, Moses brought God's law down to the Israelites, and the Israelites followed that law in exchange for protection by God. Okay? It also promotes this notion of lex talionis, and you see this in the Bible in passages like Exodus 21, verse 23 through 25. Again, an eye for an eye, a tooth for a tooth type logic. And the important thing you can know about the Mosaic Code is a lot of this is the root, really, for our legal system in the United States. So Mosaic Code relates strongly to what are considered morals. Then we move into, we go fast forward a little bit to what's called common law, which is more of what we see today. And in common law, you had basically a system that I'm going to try to draw here. I'm going to try to draw on the bottom here a very bad map of England. Wow, that is a horrible map of England. And here is Ireland, right nearby. Anyway, in England, you had this different areas of the country, okay? And before this disappears, you might have different, what are called shires, counties, various different places all around in England. And they would have different laws, different ways of dealing with crime, all right? What happened is eventually there was this Norman conquest of England, and it was in 1066. And it brought really this, fledgling country sort of more together. What happened was that judges started to go, remember I just drew that map, all these different little hundreds, shires, towns, areas within this country. These judges started to travel from one to another, to another, to another, and they started to, as I'm doing here, connect the dots, right? They would see the same kind of cases over and over again, and they'd say, we saw a case like this in Derbyshire, maybe we ought to treat it the same way as we did in York, and maybe we also ought to treat it the same way in London. So they started to travel throughout the land in circuits. And the circuits allowed them, again, to see connections between different places. So they started to document those differences. And you see the development of what's called stare decisis. You follow precedent based on other cases. Okay? These decisions become the basis for other decisions in other parts of England. Once you have circuit judges and stare decisis, again, the idea of judgment based on precedent, you begin to see the development of common law. You can think of common law as like universal law, the idea of a universal standard of law that's applied equally to all different citizens and allows for uniformity in the way that crime is addressed, sentencing, and definitions. All right. So stare decisis promotes the notion of common law, law that can be applied to all subjects of the land. Okay. This happens, I want you to know, around the time of Henry II. Okay. This is when common law starts to begin as a reality and something we very much take for granted today, but it took a while to develop. Two other concepts in Latin I'd like you to know about. These are good to know in relation to each other. Mala in se versus mala prohibitum. Okay? Mala in se are very strongly held laws. They're rooted in these core Western values. So things like, don't assault each other, don't steal, don't rape. These are laws that are strongly held and very, very consistent over time. Okay, so that's mala in se. Mala prohibitum, on the other hand, are laws that are related to contemporary public opinion. Okay, so they're not rooted in something so long-standing. A great example I think of is that when I was a kid, people smoked all the time in government buildings. Smoking, again, was seen as something that people just did. My father had a shop, he was a watchmaker, and he had a cigarette ashtray right there for everybody who would come in. The thought of that today is a little bit odd. So mala prohibitum are laws that change over time depending on the social context. You can also think about, what do we have criminal law for? What purposes does criminal law serve? And you can break these up into roughly 6 purposes, which I have here with Roman numerals. All right, go through these individually. One thing criminal law does is it helps enforce social control. So one thing you can argue is that the reason our society works, the reason we're able to do things, get along with each other, make exchanges and agree, is that behavior that might threaten this order might need to be controlled. Okay, so it allows societal well-being because threats are diminished. Roman numeral 2, criminal law discourages personal revenge or personal retribution. How many of you have ever been cut off in traffic? A car comes and cuts right in front of you, right? You get annoyed, you get angry. Maybe you feel like, man, I would like to take justice into my own hands, right? I would like to go out there and confront this person, maybe punch them, right? That would feel just to you at that moment. However, if we did that all individually, of course, we'd have chaos. Everything would be just crazy in our society. So what we instead do is we give our right to enact justice over to the state. We create these social institutions, contemporary criminal law and justice, to deal with law violators so that we don't have to deal with them on our own. We've created specialists who will take care of things for us. If we personally attack those who have attacked us, then we ourselves are subject to discipline, right? The state is the legitimate way we go through, the legitimate channels we go through for dealing with crime. The third reason for criminal law, this expresses public opinion and morality. For example, in Las Vegas, they have no problem with gambling. So they promote laws that allow for certain types of things which other places will not. For example, liquor and drug laws. In Kearney, a number of years ago, I guess, there were blue laws, which meant that alcohol wouldn't be served at certain times or certain days. In Las Vegas, you can get alcohol anytime you want to. So public opinion might vary from place to place as to what counts as criminal or not, what's moral or not. And that is one thing which criminal law allows us to do, to define. Criminal law also exists for us to deter criminal behavior. We want to stop people from even really considering crime, because if we can get you to think twice, then that means that you're already policing yourself. Right? You stop yourself from doing bad things. So when you drive along on an interstate and you see a police car there in the median, in the grass, you might check your speed, slow down, hit the brake. Um, there's this feeling that you might be subject to law, especially if there's a police officer present. So the idea of law and swift, certain, severe punishments really help deter people from doing bad things. Also, too, some people are not deterred by law. Just the mere presence of laws didn't stop them from committing crimes. So law exists also not just to deter through its presence, but to specifically punish those people who didn't feel inhibited. Okay? So sometimes law will give an escalated penalty, or I should say an elevated penalty, to people who are multiple law violators who have become what are called recidivists. Okay? And that's punishing wrongdoing. That's the purpose of some law, Roman numeral 5. Roman numeral 6, we want to maintain a particular social order. Every society has their own social order. We happen to have, for example, a capitalist social order here. So one of the major elements of criminal law in the United States is involving property crime. Okay? And that helps protect people's investment. Would we really have a secure capitalist system if anybody could take your stuff? Probably not. It wouldn't work very well. So law exists to maintain these particular social orders, maybe, that we have. There are a number of common law crimes. Again, we defined common law in a previous slide. But these days, you can differentiate between crimes that are against the person versus crimes that are against property. I'm not going to go into these in too much detail because you can read these definitions in your textbook, okay? And most of you know what some of these things are. One, for example, first-degree murder. Murder involves what's called premeditation and deliberation, okay? And it's, of course, the unlawful killing of another human being with premeditation and deliberation. Manslaughter is sometimes seen as like an accidental type killing. Again, you'll see those definitions in your textbook. I'd like you to look up the definitions of battery and assault. Those differ from each other a bit. Rape is in the process of changing. The definition is being changed. In the past, rape was sexual violation of a woman against her will, and now there are new definitions of rape which may include sexual assault against men. But the common law traditional definition was always rape was against women only. Okay, robbery, again, that's in your textbook. You'll be able to look that up. Inchoate or incomplete crimes, you can also think of these as criminal attempts. Okay, a great example of this was back, I believe it was like the 1600s. I think it was in I believe it was England. Someone had attempted to burn down a house, and there was no law on the books that said you cannot attempt to burn down a house. The guy said, well, I wanted to burn down this house, but I wasn't successful. Therefore, there's no crime. And the judges said, no, no, no. We're going to make attempting to commit crimes also criminal. Okay, so this involves criminal attempt. Incomplete crimes are also, you could say, attempted crimes. Conspiracy, working in collusion with other people, for example, to commit crime. Solicitation, you hear about this quite a bit with things like, for example, prostitution. Someone was attempting to engage in a prostitute, soliciting a prostitute for sex. A few more common law crimes you can talk about are those against property. Okay, and there are three that they talk about in the textbook, and I also want you to refer to the text again for the specifics of these definitions. But burglary has been defined in common law as a breaking in the nighttime into a house or dwelling. And of course, that is a problem because at night, people are there. People are likely there and likely asleep. So burglary came to have its own definition because of the problems likely in perhaps a burglary resulting in some type of violent crime or altercation. Arson, the burning of a dwelling or some other property. And larceny is sometimes simply defined larceny as theft. Again, the common law definitions are in your text. Please refer to those specifically, though, okay? Generally speaking, there are two things that you need to have a crime or to engage in what is considered a criminal act. The two things are actus reus, which we'll define on this slide, and mens rea. Mens rea is on a future slide, okay? We'll walk through actus reus first. This is a Latin term, and actus reus basically means the act, the criminal act, right? One thing you have to have for an act to be criminal is it has to be voluntary, right? If you, for example, are, I don't know, laying in bed, someone happens to put a pistol beside you, and in the night, you know, you're asleep, you grab it, and you pull the trigger, and you happen to kill someone, all right? That would be not considered voluntary. Therefore, you know, because it's asleep or it's the result of a reflex, therefore you really couldn't be charged with a crime for that. That's not a criminal act. However, you can also have the idea of actus reus involving a failure to act. If you don't do something in particular, that can cause something to be defined as criminal. There are three situations in particular that are important to think about. The first one is the idea of some type of relationship. And there are certain relationships that we take for granted as being those where there's some legal requirement to assist. If you're a husband and your wife is in grave danger, you have to come to her aid if she's, for example, sick or dying. If you are a parent, you are obligated by law to care for your child. Otherwise, you might be charged with child abuse or child neglect. Okay, so a certain relationship. The second type of failure to act could be if you don't abide by a contract. And some of you, I imagine, have worked as lifeguards in the past. So you then were under contractual obligation to save people in a swimming facility. Right? At one point in my life, I worked with developmentally disabled people, and I was required to take CPR classes and first aid classes. And I would be required by contract to help those people if they were in, you know, life-threatening or situations where they were having problems with breathing, for example. In one case, there was a horrible instance where I worked where there was a fellow who was quadriplegic. He could not move, and another fellow was in charge of bathing him and wore yellow rubber gloves. And when he did this, he put the fellow in the bath, and he didn't test the temperature, so it was very hot water. The fellow who was quadriplegic was scalded, and because he had been under contract to provide services for this person and had harmed him, he was held liable, criminally liable, for hurting that person. A third failure to act can be the idea of a statute. For example, you can have, in some places, what are called Good Samaritan laws, laws that require you to help people in certain situations. There is an example of this I can tell you about when I lived in Las Vegas. There was a man, and he was following around a little girl named Sharice Iverson in a casino. And this man had a friend named David Cash. And David Cash was following the man who was following the girl, right? The man and the girl ended up in a bathroom, men's bathroom, and David Cash, who was the friend of the fellow, went in and looked and saw that there was something going on there that didn't look right. He decided, I don't want any part of this. I left. I'm out of here. In Nevada, there was no Good Samaritan law, which meant that David Cash had to report whatever was happening in the bathroom. And it turned out that Sharice Iverson was killed by that man. So even though it seems like morally it would have been the appropriate course of action for David Cash to report his friend, who, by the way, his name I didn't mention, Jeremy Strohmeyer, he would have been morally obligated to report Jeremy Strohmeyer's actions. He did not. Because Sharice Iverson was not yet in a life-threatening position, there was no law, no statute in Nevada that enforced that. So depending on the state you are, you may or may not have certain kinds of statutes in place which force people to act or are holding them accountable. Sometimes, too, you can think of words as acts. Like, for example, you wouldn't want to yell fire in a crowded theater if there was no fire, because if there was, you would be held liable for any injuries that resulted from perhaps people being trampled. I just talked to you a little bit about the idea of actus reus, and I'd like to speak with you a little more now about the second part of any criminal act, and that is the notion of criminal intent. Okay, so there's the physical act or lack of act that can be related to crime, and there's what's called the mental state or mens rea. So there has to be some type of behavior or lack of behavior, and then also a corresponding mental state that goes with it in order for something to be considered crime. Okay, we have 4 levels of mens rea, and you know these intuitively, but I'm going to walk through them with you, and each one you can add a little bit to your notes if you like as I go through them. The first idea, the highest level of mens rea, is if you do something intentionally, okay, then that means you wanted to cause some specific result. I'll give you an example. If you did something on purpose, okay, that means you did it intentionally, and that is the highest level of mens rea, clear intent. Right? The second highest level is if you do something knowingly. Knowingly means that you're aware of the consequences of what could happen, right? So maybe you didn't do something because you wanted to hurt someone. That would be intentionally. If you do it knowingly, it's not that you wanted to hurt someone, but you know that you're going to hurt someone. You're practically certain, in other words, that you're going to hurt someone. The third level, the third lower level of mens rea is recklessly, doing something recklessly. In this instance, you're creating a risk of harm, and you know you're creating that. So in this case here, let me walk through it. You would do something on purpose. In B, that instance, you knew you were going to be hurting that person. You didn't do it because you wanted to, but you knew or were practically certain you would hurt them. With reckless behavior, you didn't want to hurt the person, but you knew the odds were high that you could hurt that person, and you did that thing. Okay, that's reckless. So you can think of things like reckless driving. You know there's a greater odds are of having an accident. Okay, the last level, the least lowest level of intent with mens rea is negligence. And negligence, you can think of, okay, you didn't cause this thing on purpose. You didn't do it because you wanted to hurt me. You knew you were hurting me. It's not reckless because you are knowingly creating a risk of harm. It's that you unknowingly create a risk that what's called the reasonable person would perceive. So here's the thing here. You didn't mean to hurt that person. You didn't even know how high the odds were, but you should have known. You should have known because you're a reasonable person that you were going to potentially hurt that person. There's also another type of crime called strict liability crime. And these are crimes that don't require any kind of thought, really. You don't have to do something knowingly, recklessly, these types of things. For example, if you are driving and you are going faster than the speed limit, if you say to the police officer, well, I'm sorry that I was going faster than the speed limit. I was playing with my stereo. I didn't know I was going faster. Can the police officer still give you a ticket? You bet. And the reason, of course, is because it doesn't matter. You are held strictly liable for the speed limit. In the same kind of way, you're held strictly liable for whether or not you intended to have illegal drugs on you or not. You're held strictly liable for health and safety codes in restaurants. You can't claim ignorance for those things. You're held accountable. Okay? The reason is you want to protect the public generally, so you don't have to have mens rea for those laws. There are two generally different organizational principles for criminal defense strategies. You can either have an excuse type of defense or a justification. Ignorance does not normally work as a very good excuse for a crime. Sometimes you can plead it, but a lot of the time you're held responsible for knowing law. Insanity is very tricky because the idea is that you were not mentally able to understand what you were doing as crime. There are some examples of this. I have a case that I sometimes talk about where a fellow was an illegal bookmaker. He was a bookie. He would take bets in Minnesota. And as he did this, he's obviously doing something criminal. But he was tested as having a lower level IQ and mental capacity so that he did not understand that what he was doing was illegal. Therefore, he had, it's not insanity, but it's the idea that he could not understand the consequences of his actions as a sane person would, as a mentally fully cognizant person would. Right? So there's a rule that is related to this called the McNaughton rule. And it's this notion that McNaughton rule is that if someone doesn't understand, what they're doing as a criminal because of a mental type impairment. Okay. Intoxication, again, usually not a very good excuse for a crime unless you become intoxicated maybe against your will. Let's say, for example, somebody puts a rupee in your drink and you have a blackout and you do things that you would not have otherwise done. Intoxication in that instance might be an excuse. Right? You can justify your actions too, if you want to try to, as a defense strategy. You can claim self-defense. Self-defense, you can say, works pretty well if you're talking about proportionality. So, for example, if a woman who's 90 years old starts to come at me with a butter knife, wants to kill me, and I shoot her with a .38 caliber pistol, that is not proportional, and self-defense would be a pretty poor defense strategy there. Okay, so the idea is that the threat has to be at least at the level of the harm that you inflicted in defending yourself. Right? Duress and necessity. Duress means you're under some type of threat, and sometimes that works as a defense. You can't use it, though, as a defense to kill anyone. That's not good. Necessity means you sort of had to do it. So, like, for example, if there was like a tornado that would come and you're 14 years old, you don't have a driver's license, but you needed to get away from the tornado, you get in a car and drive, a police officer pulls you over, says you don't have a license, you could argue necessity, your life was in danger. Right? Entrapment, you could say that, you know, the police were trying to get you to commit a crime that you normally would not have done through some type of setup that they've created. Right? A few more things in your text that are interesting. Criminal law changes, of course, over time, and we can talk about some contemporary trends, things that are reasonably new. Stalking was once not considered a crime. We're going to see a video eventually where they'll talk about the evolution of stalking laws, but there was a period where people could repeatedly, maliciously follow and harass someone without there being a whole lot that person could do about it. Eventually, over time, this came to be seen as a crime in its own right, as opposed to just a behavior and expression that somebody's engaged in. Lawrence versus Texas is mentioned in your textbook, and I have SC here, and that means Supreme Court. It's a Supreme Court case that found sodomy laws to be unconstitutional. Why is that important? It's important because before, sodomy laws were enforced at state levels. So you could travel from state to state, and sodomy basically means sex that is not procreative. Okay, so it can involve a whole lot of different sexual acts. But each state had its own laws, some of which were very much against sodomy. Now there was a blanket ruling at the federal level that said these laws are unconstitutional. So suddenly a whole type of crime was eliminated and gotten rid of. Finally, in Chapter 1, we can talk about ethical issues related to the study of crime and criminals. And one of the things about ethics is it's about practice, how you treat other people, largely. So a basic principle of ethics I'd like you to know is the notion of do no harm. 3 simple words. Ethical practice means don't harm someone. And that's the standard that you can use as a researcher to judge if your study is appropriate. What you will have to do if you ever do research in criminal justice or criminology, if you go through a university as I do, you have to go through what's called an IRB, an Institutional Review Board, IRB. The IRB will look at your proposal and say, okay, looks like Borchardt has done a lot of consideration over how he might harm other people, and also ways to compensate for that harm. So, for example, if someone were to do a study about something where they didn't tell the participants what it was about, they might be harming the person by deceiving them. The research subject might be deceived. So in order to avoid that type of problem, I might, as a researcher, create something called an informed consent statement so that I get voluntary consent from those people who I want to study. That's an ethical procedure. That's good and something where I'm trying to avoid harming people through conducting my research. So you could say that involves how to study people. What are some of the procedures? Whom can you study? Juveniles, for example, do they deserve special protection because they may not necessarily know as much as an adult? With, for example, developmentally disabled people, would you have a different set of ethical constraints that you might need to look into and think about in order to truly know that people are informed about what your research is going to concern? And finally, what can you study? For example, in many instances, criminologists are studying criminal acts. So this is not something that a lot of people want to reveal. It's also stuff that if, for example, you told other people about, those people might face real consequences for their actions. If you study certain types of crime, you might be able to get away with that, but if you, for example, come across someone who's engaged in a murder plot, then you're obligated to report that no matter what. So the idea of what you study, whom you're studying, and how you study, all of these things involve the principle of thinking through, am I harming my subjects? And you can also think about ethics in terms of how I might be harming people if I, for example, lie about my research or fudge data. So as criminologists, we're obligated to be ethical. Thank you.